नमस्ते, आपका कंपनी 360 के यूट्यूब चैनल में स्वागत है और ये वीडियो आपके सामने प्रस्तुत हो रहा है ILMS अकेडमी के द्वारा, जो इंडियाज़ प्रीमियर लीगल एंड मैनेजमेंट एजुकेशन पोर्टल है। गेट सर्टिफाइड टू एनहांस एम्प्लॉयबिलिटी।
मैं अनिरुद्ध आपका स्वागत करता हूँ इस विषय के दूसरे पार्ट में। अब हम देखते हैं इलेक्ट्रॉनिक एविडेंस एंड द इंडियन एविडेंस एक्ट 1872। द डेफिनेशन ऑफ एविडेंस एज गिवन इन द इंडियन एविडेंस एक्ट 1872 covers A. The evidence of witness, that is oral evidence, and B. Documentary evidence, which includes electronic record produced for the inspection of the court. Section 3 of the Act was amended and the phrase all documents produced for inspection of the court was substituted by all documents including electronic records produced for the inspection of the court. Regarding the documentary evidence, in Section 59, for the words content of documents, the words content of documents or electronic records have been substituted and Section 65A and 65B were inserted to incorporate the admissibility of electronic evidence. Traditionally, the fundamental rule of evidence is that direct oral evidence may be adduced to prove all facts except documents. The hearsay rule suggests that any oral evidence that is not direct cannot be relied upon unless it is saved by one of the exceptions as outlined in Sections 59 and 60 of the Evidence Act dealing with the hearsay rule. However, the hearsay rule is not as restrictive or as straightforward in the case of documents as it is the case of oral evidence. This is because it is settled law that oral evidence cannot prove the contents of a document, and documents speaks for itself. Therefore, where a document is absent, oral evidence cannot be given as to the accuracy of the document, and it cannot be compared with the contents of the document. This is because it would disturb the hearsay rule. Since the document is absent, the truth or accuracy of the oral evidence cannot be compared to the document. In order to prove the contents of a document, either primary or secondary evidence must be offered. इसलिए कोई भी डॉक्यूमेंट के कंटेंट को प्रूव करने के लिए प्राइमरी या सेकेंडरी एविडेंस ऑफर करना जरूरी है. While primary evidence of the document is the document itself, it was realized that there would be situations which primary evidence may not be available. Thus, secondary evidence in the form of certified copies of the document, copies made by mechanical processes, and oral accounts of someone who has seen the document was permitted under Section 63 of the Evidence Act for the purposes of proving the contents of a document. Therefore, the provision for allowing secondary evidence in a way dilutes the principle of the hearsay rule and is an attempt to reconcile the difficulties of securing the production of documentary primary evidence, where the original is not available. Section 65 of the Evidence Act sets out the situations in which primary evidence of the document need to be produced, and secondary evidence as listed in the Section 63 of the Evidence Act can be offered. This includes situation where the original document is in hostile possession or has been proved by the prejudiced party itself or any of its representatives, is lost or destroyed, cannot be easily moved, that is physically brought to the court, is a public document of the state, can be proved by certified copies when the law narrowly permits, and is a collection of several documents. बस आपकी जानकारी के लिए, hearsay evidence is anything said outside a court by a person absent from a trial, but which is offered by a third person during the trial as evidence. इसके बाद आते हैं electronic document. As documents came to be digitalized, the hearsay rule faced several new challenges. While the law had mostly anticipated primary evidence, that is the original document itself, and had created special conditions for secondary evidence, increasing digitalization meant that more and more documents were electronically stored. As a result, the abduction of secondary evidence of documents increased. In the Anwar case, the Supreme Court noted that there is a revolution in the way that the evidence is produced before the court. In India, before 2000, electronically stored information was treated as a document, and secondary evidence of these electronic documents was adduced through printed reproductions or transcripts, the authenticity of which was certified by a competent signatory. The signatory would identify her signature in court and be open to cross-examination. This simple procedure met the conditions of both Section 63 and 65 of the Evidence Act. In this manner, Indian courts simply adapted a law drafted over 1 century earlier in Victorian England. However, as the pace and proliferation of technology expanded, and as the creation and storage of electronic information grew more complex, the law had to change more substantially. Under the provisions of Section 61 to 65, of the Indian Evidence Act 1872, the word document or content of documents have not been replaced by the word electronic documents or content of electronic documents. Thus, the intention of the legislature is explicitly clear, that is, not to extend the applicability of Section 61 to 65 to the electronic record. It is the cardinal principle of interpretation that if the legislature has omitted to use any word, the presumption is that the omission is intentional. ये तो मानी हुई बात है कि लेजिस्लेचर कोई भी वर्ड का इस्तेमाल बिना कोई रीजन के नहीं करता. In this regard, the Apex Code in Utkal Contractors and Joinery Private Limited versus State of Orissa held that Parliament is also not expected to express itself unnecessarily, even as Parliament does not use any word without meaning something. The Parliament does not legislate where no legislation is called for. Parliament cannot be assumed to legislate for the sake of legislation, nor indulge in legislation merely to state where it is necessary to state, or to do what is already validly done. Parliament may not be assumed to legislate unnecessarily. The IT Act amended Section 59 of the Evidence Act 1872 to exclude electronic records from the probative force of oral evidence in the same manner as it excluded documents. This is the reapplication of the documentary hearsay rule to electronic records. But instead of submitting electronic records to the test of secondary evidence, which for documents is contained in Section 63 and 65, it inserted two new evidentiary rules for electronic records in the Evidence Act, Section 65A and 65P. The intention of the legislature is to introduce specific provisions which has its origins to the technical nature of evidence, particularly as the evidence in the electronic form cannot be produced in the court of law owing to the size of computer or server residing in the machine language and thus requiring the interpreter to read the same. Section 65A of the Evidence Act creates special law for electronic evidence. That is, the contents of electronic records may be proved in accordance with the provisions of Section 65B. This section performs the same function of electronic records that Section 61 does for documentary evidence. It creates a separate procedure distinct from the simple procedure for oral evidence to ensure that the adduction of electronic records obeys the hearsay rule. It also secures other interests such as the authenticity of the technology and the sanctity of the information retrieval procedure. लेकिन सेक्शन 65A को फर्दर डिस्टिंग्विश किया गया है एज अ स्पेशल लॉ क्योंकि वो डॉक्यूमेंट्री एविडेंस प्रोसीजर के सेक्शन 63 और 65 से अलग है. सेक्शन 65B ऑफ द एविडेंस एक्ट details this special procedure for adducing electronic records in evidence. Subsection 2 lists the technological conditions upon which a duplicate copy, which may include a printout of an original electronic record, may be used. First, at the time of creation of the electronic record, the computer that produced it must have been in regular use. Second, the kind of information contained in the electronic record must have been regularly and ordinarily fed in the computer. Third, the computer was operating properly. And fourth, the duplicate copy must be a reproduction of the original electronic record. Section 65B of the Evidence Act makes the secondary copy in the form of computer output comprising of printout or the data copied on electronic or magnetic media admissible. It provides, notwithstanding anything contained in this Act, any information contained in an electronic record which is printed on a paper, stored, recorded or copied in optical or magnetic media, produced by a computer, shall be deemed to be also a document, if the conditions mentioned in this section are satisfied in relation to the information and computer in question and shall be admissible in any proceedings, without further proof or production of the original as evidence of any contents of original or of any fact stated therein of which direct evidence would be admissible. Now we will look at the subsections of this section. First, let's understand the section 2. The computer from which the record is generated was regularly used to store or process information in respect of activity regularly carried on by a person having lawful control over the period and relates to the period over which the computer was regularly used. Information was fed in computer in the ordinary course of the activities of the person having lawful control over the computer. The computer was operating properly and if not, was not such as to affect the electronic record or its accuracy. Information reproduced is such as is fed into computer in the ordinary course of activity. Secondly, let's look at Section 65B, Subsection 3. The following computers shall constitute as single computer. First, by a combination of computers operating over that period, or by different computers operating in succession over that period, or by different combinations of computers operating in succession over that period, or in any other manner involving the successive operation over that period in whatever order of one or more. In case, in any other manner involving the successive operation over that period in whatever order of one or more computers and one or more combinations of computers. Thirdly, let's look at Section 65B, Subsection 4. Regarding the person who can issue the certificate and contents of certificate, it provides the certificate doing any of the following things: identifying the electronic record containing the statement and describing the manner in which it was produced, giving the particulars of device dealing with any of the matters to which the conditions mentioned in subsection 2, related and purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities, whichever is appropriate, shall be evidence of any matter stated in the certificate, and for the purposes of this subsection, it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it. This contention is further strengthened by the insertion words notwithstanding anything contained in this Act to Section 65A and 65B, which is a non-obstant clause. Further fortifies the fact that the legislature has intended the production or exhibition of the electronic records by Section 65A and 65B only. A non-obstant clause is generally appended to a section with a view to give the enacting part of the section, in case of conflict, an overriding effect over the provision in the same or the other act mentioned in the non-obstant clause. It is equivalent to saying that despite the provisions or act mentioned in the non-obstant clause, the provision following it will have its full operation, or the provisions embraced in the non-obstant clause will not be an impediment for the operation of the enactment or the provision in which the non-obstant clause occurs. The aforesaid principles of interpretation with respect to the non-obstant clause in the form of notwithstanding anything contained in this Act is further supported by the Honorable Apex Court in Union of India and others versus G.M. Kokil and others. Observed, it is well known that a non-obstant clause is a legislative device which is usually employed to give overriding effect to certain provisions over some contrary provisions that may be found either in the same enactment or some other enactment, that is to say, to avoid the operation and effect of all contrary provisions. Further, the Honorable Apex Court in the case cited as Chandavarkar Sita Ratna Rao versus Ashalata G. Guram explained the scope of non-obstant clause. It is equivalent to saying that in spite of the provisions of the Act or any other Act mentioned in the non-obstant clause or any contract or document mentioned, the enactment following it will have its full operation. To understand this topic deeply, you can take the certificate course on electronic evidences given by ILMS Academy. This course gives you a detailed overview about what are electronic evidences, how to procure electronic evidence, and details thereof. Do not miss to watch the third part of this topic, which will include the non-application and the special legal provisions and the relation between electronic evidence and the Indian Supreme Court.
तो इसी के साथ ये वीडियो समाप्त होता है. Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST and more. Get certified to enhance employability. Thank you for watching this video and have a nice day ahead.